Right, good morning again to my wonderful Year 2 students. Today's Tuesday, April the 4th, 2023. Again, this is a very short video on chapter 21 of the AQA Law Year 2 textbook. And the topic is on exclusion clauses. The definition, or the basic definition of an exclusion clause, is simply where the author drafts a statement to exclude completely all their liability for any loss suffered, for example, on their land. So if you go to excuse me, if you go to certain car parks, you might spot a massive notice to say you can use the car park. However, if anything happens to your property or yourself in the form of an injury, the car park owner will not be responsible. Right, as I mentioned in lessons before, please be aware that the courts frown upon exclusion clauses. They don't tend to like them. And in view of that, there are two main controls of the use of exclusion clauses. Right, there is a puddle just right next to me, so I've got to make sure I don't fall into it. The courts don't like exclusion clauses. The two main controls are statutory controls and common law controls. So if you have a look at common law controls to start off with, there are vital points that you must remember. So under the common law, the first point to note is that an exclusion clause will affect one of the parties who is party to the contract if they sign a document containing an exclusion clause. So signature is the first common law control. Unfortunately, if you don't read a document and it contains an exclusion clause, you will be affected by it. The second point under the common law is notice. So if you have notice of an exclusion clause, Ollie and Marlborough Court, and the first one regarding signature, the case you need for that will be Lestrange and Graucourt. But anyway, so notice is the second point. If you are aware of an exclusion clause, then you're likely to be affected by it. And then the third point under the common law is what we call a course of previous dealing. So if you've dealt with a particular party before and you're aware that the signature the contract you're signing includes an exclusion clause, then you're likely to be affected by it. So 3 points to remember there. Under the common law, an exclusion clause will be effective if you've signed it, or if you have notice of it, or if you dealt with that party before who has drafted the exclusion clause. Now, the other point to note under common law principles is construction. And that simply means, has the author of the exclusion clause drafted the exclusion clause to cover everything they need it to cover? So again, the courts will look at the wording, and any words that are not clear or are ambiguous will be read against the author. So construction is very important, and that's the case of Houghton and Trafalgar. Right, so they're the common law controls to remember for exclusion clauses. Now, the statutory controls are fairly straightforward. So again, make sure that you understand the relevance of the main statutory authority that controls exclusion clauses, and that's the Unfair Contract Terms Act 1977, and obviously take into account some of the provisions under the Consumer Rights Act 2015. So under the Unfair Contract Terms Act 1977, I'm just looking at where I'm going at the same time. Unfair Contract Terms Act 1977, Section 2.1 clearly states that you can never exclude liability for either death or personal injury. So if an author of an exclusion clause seeks to exclude liability for death or personal injury under Section 2.1 of the Consumer Rights Act, under Section 2.1 of the Unfair Contract Terms Act 1977, that clause, or that exclusion clause, will be null and void. Also under Section 3, you cannot exclude liability for non-performance of a contract simply means that you can't insert an exclusion clause to say we agree to do A, B and C, but if we don't do A, B and C, then we will not be responsible. That's not allowed. And then section 31 of the Unfair Contract Terms Act also deals with not being able to exclude liability for the implied terms in a contract. So essentially what you've got to remember is the common law controls and also the statutory controls. In relation to the statutory controls, one quick thing to remember is that sometimes the parties dealing with each other are considered to be of equal bargaining strengths. So if two businesses are dealing with each other, then provided the exclusion clause is reasonable, then it's likely under section 12 of the Unfair Contract Terms Act 1977 that the exclusion clause will be allowed. So a quick summary then, don't forget the definition of exclusion clauses. It's where somebody seeks to exclude their liability completely. The other slightly better clause will be a limitation clause, where one party seeks to limit their liability. So they're not completely providing nothing. They might provide, for example, £100 contribution, even though the damage may be more than that. Don't forget statutory control, so section 2.1 in particular, and don't forget that under the common law there are three key points: signature, notice and a course of dealings. And obviously do read the textbook to identify the cases that go with these points. Right, okay, so happy Easter again. Keep revising. We have limited time now, but if you make fantastic use of the Easter period, I'm sure you'll all be absolutely fantastic in the exam. Right, so I'll be out on another run tomorrow, hopefully, and I will see you all then. Don't forget, I have been setting just short 5 multiple choice questions on Microsoft Forms, so please get involved in that. And I think I'm rambling on now. So anyway, good morning, and I'll see you all tomorrow. Thank you. Bye.